A warm welcome to our first episode of Settling Disputes in the Construction Industry, a practical guide to mediation by AIADR. This will be a series consisting of 6 episodes on the topic of mediation in the construction industry, which will be uploaded to our channel in consecutive weeks. During this pandemic, the Malaysian construction industry has faced numerous obstacles such as late payments, extension of time issues, and productivity loss due to the newly adopted health and safety SOPs. Disputes start piling up almost immediately, and no one has a clue on how they will resolve the disputes amicably. Among all this ruckus, mediation has become a vital method of dispute resolution in Malaysia, especially after the introduction of the COVID bill. I take this opportunity to thank Dr. Siva Nadaraja for sharing this awesome initiative with AIADR to raise awareness through this series aiming to explore the most important question: how alternative dispute resolution, particularly mediation, could benefit Malaysian parties, including employers and contractors. In this episode, I will discuss the impact, issues, and challenges that the Malaysian construction industry faces due to the pandemic. Then I will move on to answer the question, why mediation, which I believe is a common question asked by many people without legal knowledge or understanding of the process, particularly in the implementation of the government initiative and together with the advantages of mediation. As we are aware that in many countries, including Malaysia, there is an increase of viral infections from Covid-19, prompting nation-wide lockdowns and other restrictions of movement and closure, for instance, MCO, CMCO, EMCO, and RMCO. Beyond any doubt, the Covid-19 pandemic has wreaked havoc in many areas of the economy, and the Malaysian construction industry is no exception. Most construction work have halted across the MCO, with the exception of crucial or needed services, resulting in 30% reduction in labour and income, as well as about 40% reduction in construction material consumption. Contractors continue to face disruption even after the MCO is withdrawn. One such disruption is the need to include tight standard operating procedures on health and safety measures, SOPs, at the construction sites. Such disruption has prevented them from carrying out their works as originally and normally envisaged. There are generally 5 issues and challenges faced by the Malaysian construction industry that I have identified. Firstly, COVID-19 has had direct financial impact on the vast majority of contractors and developers due to the lack of net or operating earnings caused by the termination of employment. Suppliers issuing the required supplies suffered significant losses. The implementation of MCO meant that work and payment were suspended, and contractors and other parties responsible for the ongoing cost of rent, salaries, and fixed costs. Secondly, our government has designed Section 70 of the Temporary Measures for Reducing the Impact of Coronavirus Disease 2019 Act 2020 to act as a statutory force majeure, which provides temporary protection to the defaulting party's inability to continue with any contractual obligations caused by the measures, unforeseen circumstances, and the difficult period under the Prevention and Control of Infectious Disease Act 1988. Furthermore, standard form of contracts on construction work such as JKR 203A, the PAM 2018, and the International Federation of Consulting Contractors, FIDIC, have obligated contractors not to rely on any contractual clause addressing excusable delays automatically applied to the COVID-19 pandemic. Thirdly, where their projects have paused and all site activities have ceased, few contractors have successfully claimed for extension of time for the MCO period under the contract. However, many contractors, on the other hand, often struggle to obtain additional time extensions for events after the MCO. Now, fourthly, following the MCO period, contractors are faced with issues such as the implementation of new health and safety SOPs, worker shortages because of the travel ban imposed where the decrease of supply of foreign workers, restricted working hours, supply chain delays, rework after long suspension, disruption due to worker limits imposed by social distancing requirements at the workplace, and so on. Such delays and disruptions undoubtedly reduce productivity and have created further delays in project implementation deadlines, resulting in increased expenses for all the parties involved. Lastly, the materials, subcontractors and supply chain sectors are among the industries that are severely impacted. The material supply chain rippling effect halted the manufacturing, issuance and distribution process. Imported supplies and off-site construction components such as tiles, steel and internal fittings are in short supply, causing delays and rising costs for the builders. Now, you must be wondering why and what on mediation to do in relation to the construction industry disputes. As we understand, mediation is a method by which parties choose an impartial, neutral third party, the mediator, to assist the parties to resolve their disagreement. The mediator's function is to encourage conversation and discussion and towards an amicable settlement rather than to adjudicate, since the mediator will endeavour to provide ideas or recommendations to assist parties in reaching a mutually accepted settlement. In other words, mediation is a non-formal method of assisting parties in reaching a mutually beneficial agreement. To the question why mediation, I will answer it in a twofold approach. First, in respect to initiatives that the Malaysian government has taken towards mediation during the pandemic, and second, in respect of the advantages which mediation as a dispute resolution facility offers. The Malaysian government has introduced the Covid-19 Act 2020 to reduce the impact of Covid-19 pandemic on the society. Section 7 of the Act prohibits the enforcement of a contractual right against a defaulting party if the default is caused by the defaulting party's inability to perform a contractual obligation. The Act also contains mediation as a dispute resolution method to facilitate a quick out-of-court settlement of disputes arising out of such circumstances. Further, in a media statement in 11th November 2020, the Prime Minister's Department announced the establishment of a mediation centre, Pusat Mediasi Covid-19 PMC-19, to oversee mediations commenced under the Act. PMC-19 allows for the mediation of any dispute originating from the parties' incapacity to perform a contractual obligation arising from any kinds of contracts listed in the Schedule to Part 2 of the Act, applicable contracts as a result of Covid-19 control or prevention measures. PMC-19's main responsibility is to oversee the mediation process from start to finish, accepting and processing nationwide online applications to appointing mediators and handling appeals. For the benefit of the construction industry, the applicable contracts under PMC-19 include the following: construction work contract, construction consultancy, and any other contract related to the supply of construction materials, equipment, and workers in connection to a construction contract. Performance bond or equivalent that is to be granted pursuant to a construction contract or supply contract, and finally, professional services contract. If the parties are unable to refer their dispute to mediation to PMC-19 as an alternative, Parties may refer their dispute to other mediation service providers such as AIADR, Malaysian Mediation Centre, or any other private mediators. Moreover, in line with the government's efforts to alleviate difficulties faced by M40 and B40 groups during the pandemic, the government sought to bear the full cost of the mediation service provided through PMC-19 if the applicants fall under B40 or M40 or micro enterprises with sales turnover below 300,000 or less than 5 full-time employees or small and medium-sized enterprises. It is evident from these government initiatives it aims to encourage members of our society to engage in the mediation process in resolving disputes faced during this pandemic. This is to reduce the backlog of court cases and provide the parties with a more efficient option. Now, what are the advantages of mediation? The key benefits of mediation over litigation is namely reduced costs and time. It generally takes 12 to 18 months for a case to come to trial in the High Court, and the costs involved in it are normally significant, whereas mediation sessions usually take no more than a day or two. Mediation can be arranged quickly, is logistically easier and significantly cheaper. Mediation also has the advantage of being a confidential process which can result in a confidential settlement agreement if the parties so wish to have so. Furthermore, for construction disputes, mediators usually have experience in the construction industry. While mediation in Malaysia is generally governed by the Mediation Act 2012, mediation under PMC-19 is governed only by the Covid Act. The rules governing the mediation process administered by PMC-19 are the PMC-19 mediation rules. The power to determine the appointment and role of the mediator and the conduct of mediation pursuant to the Act rests with the Minister in the Prime Minister's Department in charge of law. In the event a party is dissatisfied with the decision made through PMC-19, an appeal can be made online, and the decision on the appeal will be notified via email within 21 days of the date of receiving the complete set of documents. Upon conclusion of the mediation, parties are required to enter into a mediation settlement agreement. The settlement agreement shall be binding on the parties. In the event of a breach, the affected party can bring the matter before the court for failure to comply with the settlement agreement. Now, what is AIADR's efforts in promoting mediation? We have responded to the government initiatives and the rise of the need for mediation. We have launched our own initiatives to assist our members and the community through our rules and courses. The AIADR mediation rules have been launched to cater for drastic change that was caused due to the Covid-19 pandemic. The 2020 rules have been carefully structured to ensure that it is comprehensive, anchored on the principles of reconciliation proposed by the UNCITRAL, ensuring confidentiality of the process, impartiality and neutrality, party autonomy, equality and balance of powers, independence of the mediator, legality, cost efficiency, and with guided steps to ease lay parties through each of the process. Hence, it would be effective for the parties to resolve their disputes too. Moreover, mediation rules are available in 2 languages, English and Chinese. I would like to draw your attention to AIADR's upcoming mediation course. AIADR believes education as well as one's professional development. As Nelson Mandela once quoted, "Education is the most powerful weapon that can be used to change the world." The mediation course reflects AIADR's objective to facilitate a learning-based approach in understanding mediation mechanisms in an in-depth manner. It contains a balance of practical and theoretical learning for participants. It will be led by experts in the mediation fields. I believe that through this course, it will set a milestone in increasing awareness for mediation in the community. For more information, please stay connected with our ADR Secretariat for updates through our website and social media. In conclusion, although the COVID-19 pandemic has severely impacted the construction industry, it is worth noting there is a tide in the affairs of man, which taken at the flood leads on to fortune. At this crucial moment, with various efforts by the government and several institutes like AIADR, mediation has come as the fortune to mitigate the hardship faced by contractors and other parties. I sincerely hope that this series will broaden your perspective, give you a better grasp of dispute resolution mechanisms other than litigation. There is always an alternate option available when you think that you are at a dead end. Thank you for watching this, and we will share more in our next episode. Stay tuned.